witnesses. Today is the 28th of October 2025 in the Magistrate's Court of Windhoek, sitting at JP Karwahe Street in the matter between Immanuel Mulunga and 14 others. Case number 854 of 2025. Before court is Mr. Cornelius Willemse, the applicant in the bail application. Presiding officer, Ms. Muharukua, for the state, Ms. Lilungwe. For the applicant, Mr. Isaacs, together with Ms. Ipinge. Matter before this court for judgment, and we are ready to receive judgment.
May it please you, Your Worship, I do confirm my appearance on behalf of the applicant in this matter with the assistance of Mrs. Ipinge. I see my client is still in the gallery. May I just ask if you move to the dock?
Mr. Willemse, may you please move to the dock?
Thank you, my lady. Your Worship. Your Worship, may I also ask, I would assume it's a lengthy ruling, if he may be seated during that time. Thank you, Your Worship.
The court will proceed with its judgment. This court is seized with an opposed bail application that commenced on the 9th of September 2025. The matter involving the applicant, at that moment in time, one of 15 other accused persons, and the applicant being accused number 2 in the main matter. The applicant was arrested on the 8th of July 2025, and he brought an application for a formal bail hearing before this court on the 9th of September 2025. The applicant is represented by Mr. Boris Isaacs and the respondent, the state, by Advocate Lilungwe. The applicant is facing a number of counts. I would not go into the counts. They are common cause. The grounds for objection by the respondent, the state, is that firstly, there is a risk of abscondment. Secondly, the fear of interference with investigations. The seriousness of the charges. Fourthly, the granting of bail would not be in public interest or the administration of justice. That the accused person is facing serious charges and that the state has a strong case. Further, that there are also outstanding suspects and outstanding investigations. The applicant testified that he is 52 years old and holds a dual citizenship of both Namibia and South Africa. He was born in Keetmanshoop, Namibia, and completed his grade 12 in Upington, South Africa, his diploma at Cape Peninsula University of Technology, Stellenbosch. He testified that at the time of his arrest, he resided in Hockland Park, Newtown Street, in Windhoek, and due to his arrest, he has been evicted from the rental property, and he informed court that he resides at Farm Okutambo, which is about 45 kilometers from Okahanja, and he would be a resident at that particular place should he be released from custody. His testimony was further that he is divorced with 3 daughters, the eldest being 29 years old and the youngest twins being 20 years of age. He testified that his ex-wife is a South African citizen and his 3 daughters born in South Africa who are Namibian by descent. He testified that his eldest daughter is married to a South African citizen in Paarl, South Africa, and his 2 other daughters, are studying at Varsity College in South Africa, and they reside in Walvis Bay with their ex-wife, their mother, when they're not schooling. He further testified that his father is deceased and his mother, who is 75 years old, born in South Africa, currently residing in Walvis Bay. He has 3 siblings, 1 brother who is 40 years old, and 2 sisters, ages 40 and 45 years, and are all resident in Namibia. The applicant testified that he has 2 passports, a Namibian passport and a South African passport, which he voluntarily, or which was handed over to the anti-corruption officers, ACC, and he has not left Namibia for a period longer than a month when he visits his daughters or when he goes on business. He testified that he has been employed in the upstream and downstream petroleum sector. He explained to court, or he testified that he was employed at BP South Africa for 8 years and thereafter started his business. I will not go into the many employments that he has. He stated that he was employed for Namcor, the Namibia Petroleum Corporation Trading, from 2008 to 2011. And thereafter he worked at Scorpion Zinc from 2018. I stand corrected. He thereafter joined Namcor Trading until 2022 as a consultant. And in June 2022, he worked as a distribution supply manager. He testified that he's currently self-employed with farming businesses, and he is a distributor of alkaline water, selling sausages, rations, meat products, and he earns about $150,000 per month from the farming, which covers his expenses. He earns a further $95,000 per month, and in total, he indicated that his earning income is about $250,000 from the various businesses as well. The applicant informed court that he owns Farm Okutambo and Farm, I'm not sure if I can spell this, but Farm Drishoek Vlakte. He testified that he purchased he purchased goats, sheep, cattle, and pigs and chickens. He owns a block of flats in Rehoboth, which he obtained in 2016. And he used to sell or used to buy fish in Walvis Bay at the time that he was working there, has cold unit storages, and sells at the open market or at Havana Fourway and banks the proceeds. He testified that he had 3 farms and rented 2 adjacent farms in Commerce Hockland. He further informed court that he has been making a living since 2005. He has sold the farm, one farm that he had for $2.2 million in 2023 and purchased farm in intervals of payment. And the block of flats is financed with Standard Bank, which is collateral for the farm of Kutambo, which he purchased in 2024. He further testified that he owned 3 townhouses, which he sold in 2020, and 2 flats in Cape Town that he sold in order to focus on the farm of Kutambo, as he had planned to turn the farm into a game farm or a game lodge. He further testified that he owes $9.7 million on the farm Kutambo. It's a mortgage, and further he has made improvements to the value of $30 to $35 million on farm Kutambo. He testified that he has a timeshare in South Africa at Sun City, where he purchased rights for use for the Christmas period for 10 years, and he does not intend, and if he does not intend to make use of this timeshare, he sells that to someone else for the holiday period. He further testified that he had one Ludwigstoff property and an Avis property that he sold in the year 2023 or 2024 that he provided as collateral. He indicated that the mortgage bond lies with Nedbank Namibia. He testified that he was unable to provide the title deeds as most of his information on his laptop has been seized by the Anti-Corruption Commission officials on the date of his arrest. He further testified that he owns 3 motor vehicles, 1 Jeep, 1 Golf GTI, a Toyota Hilux, farming equipment, tractor and trailer, and that all the vehicles are financed, bank financed. He further testified that he owned a logistics and trucking company called Parkwood, and he owned a nightclub that he sold for $700,000, maybe $1, a clothing company in Walvis Bay that he sold for $300,000, maybe $1, and he had 3 butcheries in South Africa that he sold years back in South Africa. He further informed this court that he pays for his daughter's school fees and expenses and paid for his eldest daughter's salary during the time of COVID-19, which he paid up until last year, 2024. That he pays for his 5 employees at his farm, and he owns an account at Game and American Swiss. He informed court that he makes a monthly payment of about $15,000 and about a yearly payment of $800,000 to Agribank. He informed court that if he does not pay all these expenses that he has, all his year's work will be destroyed, and his properties repossessed. He testified that he has one previous conviction relating to driving under the influence of alcohol, which he received years ago. Applicant testified that Namcor Trading is a private company, a PTY Ltd, that operates autonomously and does not get assistance from Namcor Holdings. Applicant informed court that he has worked for Namcor. He does work for Namcor, and Namcor Trading, as he stated, has no money to purchase fuel, that Namcor supplied international oil companies with parent company guarantees while misrepresenting himself to international suppliers and bought fuel on credit. The applicant testified that he was employed as a supply and distribution manager from the 1st of June 2022 and resigned from Namcor Trading on the 15th of October 2023, his last working date being the 15th of November 2023. Applicant informed this court that he suffers for diabetes mellitus and was hospitalized and almost went into diabetic shock the day after his first appearance, which was a result of the ACC officials failing to take him for medical attention timeously. On that particular date, he certified that he has not taken, since his arrest, medication for the 3 days. He provided the court documents of his treating doctor and the chronic medication prescribed. The applicant testified that on the 8th of July, around 11 a.m., Mr. Nellis Becker, who identified himself as a police officer in the presence of Mr. Inambao, he further testified that he was refused to call any lawyer and his cell phone was confiscated. The applicant testified that his house in Hockland Park was searched by Mr. Becker and Mr. Inambao. They searched the house, seized his cell phone, his laptop, and some documents, bank cards, and requested for the keys to one of his vehicles. He informed court that he was not provided with any search warrant upon request from himself. He testified that he was not informed in detail of the charges that he was arrested for. He only found out on the date of his first appearance at court. The applicant testified that his farm has an estimate of around about 200 goats. Similar in number were sheep, 300 pigs. He also had a number of chickens, and he receives income every 3 to 6 weeks on these chickens and 12 to 15 months on the cattle. At some stage, he had 350 cattle, and he testified that he had a herd statement from AgriBank where the animals were valued, and that was about between February and March 2024. He testified that the policies he had to pay, estimating to an amount of 20,000 and insurance of property around 17,000. The applicant informed court that he had a professional relationship with his co-accused, Mr. Immanuel Mulunga, Jennifer Hamukwaya, and Olivia Dunaiski. He narrated that he met Victor Malima in 2021 when he was a consultant at Namcor dealing with EcoFuel, and they briefly met in 2022 at an unspecified place. He further, or at a restaurant, he indicated. He testified that he does not know Peter Elindi or Malakia Elindi personally, and briefly met them at a non-specific place in 2021. The applicant testified or explained to court that during his employment at Namcor, he formed part of the credit committee that followed a credit policy which set guidelines for consideration of extending credit terms to Namcor's customers for the purchase of fuel. The applicant testified that the committee looks into ad hoc requests of customers requesting for increase of credit. He further testified that as part of the credit committee, they assess credit limits of new customers. The credit committee comprised of the executive for finance and administration, executive for downstream supply and logistics, executive for corporate governance, finance manager downstream, and commercial manager and financial accountant. The applicant informed court that the credit committee comprised of 2 executives that recommended the credit assessment It does on its own merit, and the credit committee needed to have a holistic view when taking into consideration credit assigned and credit limits. The applicant testified that the system of credit assigned has an anomaly or has anomalies that customers may exceed their credit limit and still be able to obtain further credit beyond authorized limits, and many companies were involved. The exceeding of the credit limit, he testified, has been accepted over the years, and he informed court that he never dealt with the customers of Namcor. He testified that as per the credit policy, a credit guarantee is preferred that provides assurance in the event of default. The credit limits have been waived, and sometimes insurance guarantees were accepted. The applicant testified that Enercon Namibia supplied fuel to the Ministry of Defense and Namibia Wildlife Resorts, and he testified that Enercon had a credit limit of 15.5 million with Namcor. When addressed on the charges, applicant referred to the fuel supply agreement with Enercon that was signed on the 16th day of March 2022 by the Managing Director, Mr. Immanuel Mulunga. Applicant testified that he was a consultant at the time and the agreement was entered into and was not aware of that agreement at that point in time. Applicant informed court that the agreement gave birth to the asset acquisition entered into by Namcor and Enercon in respect of Enercon's equipment such as pumps, canopies, tanks, and related equipment belonging to Enercon at a market-related value to be established by the parties' joint technical team, who negotiated within reasonable time, and the amount set off against the debt owed by Enercon. The applicant testified that he had a limited role when he joined Namcor as a logistics manager or distribution manager in the asset acquisition. Mr. Mulunga, the managing director, had asked him to be involved in the asset purchase due to his vast experience in asset sales and marketing in an advisory role, and he had no decision-making powers. The decisions were made by the marketing team. Applicant elaborated that the team that was tasked to facilitate the deal was a sales and marketing team led by the executive sales and marketing or the acting sales and marketing team, who consisted of Mr. Davis Maposa, who is not an accused, Ms. Olivia Dunaiski, commercial manager, who is in the main matter, I believe, accused number 4. Applicant testified that he is not part of the joint technical team for the asset purchase, or the managing director had already instructed. During the period of May 2022, the executive for engineering and technical services, Mr. Shefeni, who is not an accused in the matter, as well as Mr. Michael Ipanda, the engineering manager, who is also not an accused in the matter. Applicant informed court that without the verification of the assets, the purchase of the assets is not possible, as verification has to be done to verify the existence of assets, their lifespan, and the value of the assets. He elaborated that the legal and sales team would have to do due diligence. The legal team being headed by Nyambali Medical, who instructed the legal manager, Ilda dos Santos, who are also not accused in the matter. Applicant testified that he was never involved in the drafting of the project feasibility study, which is compiled by Mr. Sam Hashile, the financial analyst for Namcor Trading, who's not an accused in the matter. He further testified that he was never involved in the drafting of the contract, neither was he involved in physically assessing or going to see whether the assets exist, and neither did he instruct Mr. Hashile to compile the feasibility study. He testified that his role was advisory and making sure that everything is done prior to the submissions of the managing director. The applicant testified that himself, Mr. Shefeni and Mr. Michael Ipanda, who were part of the engineering and technical team, along with the financial analyst, the marketing team consisting of Mr. Davis Maposa and Olivia Dunaiski, and legal manager Hilda dos Santos were part of a meeting discussing the outcome of the verification and the valuation. The applicant testified that after the evaluation and verification, a discounted cash flow or project feasibility report module is made, and the sales and marketing team compiles a memo based on the report. He testified that the study was to ensure that the assets with the supplier volumes were profitable. Applicant explained to this court that there are many ways to obtain customers and secure volumes. He informed court that firstly, by entering into a fuel supply agreement without any investment, which does not exclude exclusivity, as a customer who owns petroleum equipment can shop or fuel at any petroleum distributor, or alternatively, they can invest into the petroleum assets for security of supply to obtain exclusivity. The applicant further testified that Enercon provided an asset register that listed the storage facilities and installations, which proved ownership of assets. Applicant testified that as part of the asset purchase agreement, Enercon desired to sell to Namcor Trading if its right titles and interests in the assets listed in the annexures. Its rights listed in the annexures. He informed court that one of the many ways to secure a customer and secure volumes and ensure exclusivity is to invest in petroleum assets and equipment, and to secure. At the time, Enercon had a contract with Ministry of Defense, of which at the time 9 years remained, and Namcor sought to go after the business of Enercon for profitability as part of the business of Namcor and to make it profitable. The applicant testified that once the asset purchase agreement was enforced and the asset purchased, Enercon could not procure fuel from any other supplier or oil company. Further, in the asset agreement, which was mentioned, clause 2.2, Enercon warranted and represented that the assets were not part or subject to any lien, cession, or claim, and by clause 2.3, that the assets would be transferred free and clear of any liens, claims, mortgages, security, interest, pledges, encumbrances, or restrictions on transfer of any kind or nature. The applicant further testified that Ms. Olivia Dunaiski, the fourth accused in the matter and the commercial manager, authored a written internal memorandum dated 8 July to the managing director, Mr. Mulunga, who is the first accused in the matter, and requesting for approval, who's the first accused in the matter, for approval to take over Enercon's assets. The internal memorandum was ordered by Ms. Olivia Dunaiski, supported by Mr. Davis Maposa, the acting executive sales marketing, and further supported by the applicant as acting executive supply and logistics at the time, and recommended by Mr. Nestor Shefeni, the executive engineering, and approved by Mr. Immanuel Mulunga, the managing director. The applicant elaborated the asset takeover as the project feasibility model financial, and it was profitable for Namcor and would increase Namcor's revenue and profit margins, as Namcor would be, as he stated, a minimum of 450,208 litres would be involved based on the asset takeover, which was viable based on the documents that were reviewed. The applicant testified that Enercon had an agreement with the Ministry of Defense for 15 years, of which 9 years was left, and the idea was that the volumes. And the applicant testified that in essence, the goal was to make a profit and reduce payback period and the initial investment as well as the payback calculations. Applicant testified that at the time of the agreement, a decision was made that Namcor paid 25 million, but 35 million was paid on the sales and marketing team in conjunction with the finance team that decided to pay 35 million into the operational account. Applicant testified that Enercon had 3 operational accounts. One where the debt was ceded to EcoFuel to Enercon in March 2022. That was a debt of 73 million owed to Namcor. Applicant testified that this was moved into a debt recovery account, which was approved by the board of directors of Namcor, which is noted in the session agreement, and 2 other operational accounts with Namibia Wildlife Resorts, NWR, and Ministry of Defence. The applicant testified that the debt of Enercon at some point reduced below 15.5 million, and there was a debt recovery that was also reduced from 73 million to around about 68 million. He testified that it was not unique, as Namcor had done similar in the past in 2000 and 2010 with Langer Heinrich uranium mine in Swakopmund, investing in tank pumps and related piping equipment. The applicant testified that he was not part of the decision that approved the amount of 73 million of debt ceded by Enercon to EcoFuel, or EcoFuel Enercon, and the debt recovery of 73 million was approved by Namcor board. He further testified that Enercon approached Namcor with a repayment plan in May 2023, which the board rejected later that same year. He testified that Namcor has taken Enercon to the civil court and also made a criminal case out of legitimate commercial transactions. The applicant further testified that he would plead not guilty to all the charges. He stated that he did not receive any 3 million from either Enercon or Irongo Petroleum CC. He did not misrepresent to Namcor or anyone that he was part of a team that deals with acquisition of assets, and he joined the team upon the request of the managing director from an advisory point of view. He testified that he is not guilty of the alternative counts to count 9. He never authorized fuel above the credit limit to Enercon and Petroleum CC in the amount of 3 million. He never corruptly facilitated the acquisition of assets in the amount of 53,212,000, and never did he authorize the supply of petroleum products above the credit limit to the loss of 30 million. He further testified that the final authorization of approval lies with the managing director. The applicant denied count 10 as well for corruptly receiving gratification in the amount of 1,040,000, as well as count 11, fraud, and the alternative of theft by false pretense. He testified that his business of Parkwood received 1.40 million for the logistics transport. He testified that he never received reward for facilitating the purchase of 9 service stations by Namcor from Enercon. He further testified that he never stole 1.40 million from Enercon or from Namcor. The applicant testified that he did not have the power to authorize or approve fuel supply beyond what is prescribed in the policy. He further testified that the final authorization is the managing director. He denied count 13, that he never received 4,050,000 from Enercon or Irongo Petroleum. The applicant further denied count 14, 15, and the alternative to count 15. He testified that he did not conspire with Namcor staff members or Enercon to commit crimes. He did not receive 4,050,000 in his personal account as proceeds of unlawful activities. He further denied count 16 and 17. He testified that he never received 327 million into his bank account. He never failed to declare income of 60 million. He narrated that he submitted his tax returns 2024 to pay tax with now awaiting objections. His lab has officials at the Novice and to provide court additional events. That for an extension to file documents. With the advice of his accountant, he had filed 0 returns on some months. Applicant testified that he met Malema briefly in 2021, and in 2022 he met him at a restaurant, coincidentally discussing farming, which culminated into farming business transaction. He testified that he felt no conflict, as at the time Mr. Malema's business of quality meat supply had no relation to Namcor, or his business relationship ended with EcoFuel, and which they proceeded to Namcor, a transaction which he was not involved in. He further testified that Malema, through his quality meat supply CC, paid on a 60-day supply term and not 30-day supply term. He testified that the invoices and delivery notes, which reflect legitimate transactions, were in boxes and were moved from the house he sold and also at the farm. He testified that he has been farming since 2011, and he's been selling cattle due to the drought. He has a slaughtering facility on all of the farms, meat sows, minces. He testified that Mr. Malema was happy to receive the carcasses, and he has a meat trailer with a cold storage at each farm that he owns. He further testified that he would deliver at the offices, sometimes opposite Marua Mall, and deliver to informal traders at single quarters. He further testified that Mr. Malema would sign a delivery note and he would invoice based on the delivery note. He confirmed the payments of 150,000, 960,000, 350,000, 500,000, 550,000, and 50,000 from Quality Meat Supply for beef carcasses in April 2022, 7 July 2022, 27 July 2022, 1, 8, and 11 November. He confirmed the payments of 960 were several invoices of multiple suppliers. He further informed court that he had over 300 cattle in 2024, which he had reduced, and in the year 2022, he had roundabout more than 300 as opposed to the 2024. He said probably between 50 and of the 300 cattle that he owned. He testified that he also made cash deposits multiple times of about 5,000 in November 2022 for goats that he sold privately. The applicant testified that he had received an amount of 40 for Mr. Malema's business, which at the time was not a Namcor customer. He invoiced for cross-border transportation to the Congo, which he had an invoice and provided to court. He further testified that he sold containers to Mr. Malema at some point as well, at the time that he was based in Walvis Bay. The applicant testified that he is the main breadwinner of his family. He makes all the payments. He is behind in payments due to lack of income, and continued detention would result in him losing everything by the time trial commences. He testified that he can afford bail of between 10,000 to 20,000 Namibia dollars with the assistance of his friends and family. He further testified that he wishes to clear his name, and he has known of these charges since 2023. He will not abscond. His passports are with the Anti-Corruption Commission. He will comply with any bail conditions that are set by the court, and that he's willing to report any day the court will impose, and would prefer to report near his farm, Okutambo. The respondent's case. The state called one witness. The respondent called one witness, the investigating officer, Mr. Obert Inambao, who testified that he is an investigating officer and chief investigating officer employed at. Mr. Inambao testified that he was assigned as an investigating officer in the matter since February 2024. He received the docket on 7 June 2024, referred by Namcor to the ACC, of which matter involved 331 million. The two main allegations that the entities of Enercon Namibia, Ironga Petroleum CC, were corruptly supplied with fuel by Namcor to the value of 277 million. That staff members of Namcor had corruptly authorized the supply of fuel above the sanctioned or authorized credit limits, and further that Mr. Mulunga, the applicant, Mr. Mulunga, corruptly attempted to acquire assets, fuel storages, and all service stations belonging to the Ministry of Defense, situated at the 9 military bases across the country. Mr. Inambao testified that the fuel storages could not be transferred to Namcor because they were incumbent to the Ministry of Defense through an agreement already in force, and that this was in force between the Ministry of Enercon and the Ministry of Defense for 15 years. Mr. Inambao testified that this matter was reported after Namcor had already begun investigations and reported to Namcor, and the police had listed the applicant as a suspect in the matter, and as a result, a decision was made that the Anti-Corruption Commission officials and Namcor would work together. Mr. Inambao testified that he interviewed witnesses, obtained statements, records such as agreements, internal correspondence, invoices, payments, instructions, and that with all the information collected, the figure came to run about between 274 and 277 million. Witness testified that Mr. Inambao testified that the agreement between Enercon and Namcor came into force before the asset purchase agreement. He testified that his investigations revealed that on the 19th of November 2021, Enercon was provided with a 5 million credit guarantee, of which they transacted on, and such agreement was cancelled on 29 November 2021 by Mrs. Jennifer Hamukwaya, who is an accused in the matter. He testified that the agreement was cancelled due to an issue that was never revealed. He further testified that on the 2nd of March 2022, EcoFuel Investment CC, owned by a certain Martha Namonjebo and a certain Johanna, with Mr. Malima, ceded all the liabilities that they have with Enercon to the value of 73 million. And as a result, of the agreement that was entered into with EcoFuel Investment CC and Namcor on the 4th of July 2018. He testified that when a customer enters into an agreement or is onboarded, as he indicated, the customer needs to provide a credit guarantee, which is a safety net that was meant to protect the interests of Namcor should the customer default in payment. He further testified that Namcor supplied fuel to Enercon and they were not required to pay a credit guarantee, as all purchases by Enercon to Namcor were accompanied by purchase orders of the Ministry of Defense, which was served as a guarantee. He further testified that investigations reveal that There was a Bank of Windhoek account of which Mrs. Jennifer Hamukwaya was a signatory, where a payment was made over to Namcor. Testified that this account was opened on the 26th of October 2021 by the directors of Enercon that gave Mrs. Hamukwaya access, which was entered into on the 16th of March 2022. Mr. Nyambali testified that the fuel supply agreement between Enercon and Namcor was signed, and the applicant was involved when he was employed as a manager of supply and logistics for Namcor. Mr. Nyambali testified that after the fuel supply agreement, they were to obtain equipment from Enercon, and an email was sent directly to the applicant dated 22 April, reflecting that 9 bases that Enercon wanted to sell to Namcor needed to be visited upon, authorized by Mr. Mulunga, the MD. He testified that Mr. Mulunga authorized Mr. Nestor Sheffield at the time, the consultant found that Mr. Willemse had indicated the project, and for the discount cash flow ability report was required with urgency. He further testified that an internal memorandum was prepared by Mr. Lydia Dunaiski for approval of the acquisition, assets including fuel facilities and sums, shade blocks and canopies, and he stated that the memorandum dated 8 July indicated that Enercon was in debt of 25 million. However, it not 7 million. For the testified that it was ordered by manager, supported by Mr. Davis Maposa, the acting executive of applicant, was the acting executive supply logistics, and approved by Mr. Mulunga. Mr. Nyambali further testified that for asset takeover for the year 2022 and 2023, based on the approval by procedures, would require board approval and indicating any expenditure above $25 million. In the investigations, though by the budget policy list of procedures by procuring goods and services, never conducted. The witness testified that Namcor had a schedule of authority that provides for the management to exercise powers within levels of authority and prevents abuse of office. He testified that the goods above 25 million, works above 35 million, consultancy services above 20 million, and non-consultancy services above 15 million require the central procurement board, and further 500 million of 25 million and 35 million and consultancy work above 20 million and non-consultancy services above 15 million require the procurement committee and also to be approved by the managing director. The witness testified that no procedures were followed at all regarding the takeover of the assets, the budget only made provision for 25 million, and anything above 25 million, they were to reallocate the funds from one vote to another to make up the 53 million, and board approval was still required. Mr. Nyambali testified that the legal accepted the offer, at which point the commercial offer was provided to the legal team, and the legal team was tasked with finalizing the agreement or memorandum. Mr. Nyambali testified that an offer was made to Enercon to acquire the bulk storage facilities for 53 million. 35 million was allocated to the debt, to the allocated debt, and 30 million was to be paid to a transactional account, and 5 million to the old debt. He further testified that the Ministry of Defence had entered into a memorandum of agreement with Enercon on a 15-year exclusive petroleum product supply agreement, and Enercon being the exclusive supplier of all petroleum products, infrastructure developments related to the management and supply of any petroleum product to the Namibian Defence Force. He testified that the agreement between Enercon and the Ministry of Defence was in force up until 2024, when the Ministry of Defence terminated the agreement. He informed court that the Ministry of Defence was not aware of the agreement between Namcor and Enercon until a matter was instituted by the former. Mr. Nyambali testified that after the asset purchase agreement came into force on 18 July 2022, between Namcor and Enercon, the applicant received an amount of 150,000 from a business called Quality Meat Supply into his personal account . An amount of 150,000 from correction this district property last year. During the investigation, the premise was just a residential house. Testified as far as the beneficial owner, it was established that Mr. Samaneka of quality and the person to whom the business is registered as a proxy. He testified that payment to the other of the applicant, Ms. Dunaiski, which shows that the internal memorandums of information received from applicant, which reflects that he was involved in the assets in question. The witness testified that Enercon that the act was that it was he further testified that invoices received business units, confirming where the services were rendered and under which certification it did not occur. He further testified that an amount of 35 million was paid by Enercon to Namcor to offset their debt and a further 18 million was paid into a second account of Enercon on 19 July 2022. He testified that following such payment, the bank account reflected a payment of 9.5 million and was paid into the Eco Trading CC. At the time it was owned by Mr. Malima. He further testified that on 20 July, 1,470,000 was paid into the account of Quality Meat Supplies. He testified that through their investigations on the same date, the bank account reflected an amount of 960,000, which is credited into the account of the applicant. He further testified that an amount of 500,000 account of Panduleni CC, which is 100% owned by the husband of Mrs. Hamukwaya, an accused. And at this point, applicant was employed as a manager of supply and logistics at Namcor. He further testified that on 21 July, an amount of 1,040,000 was paid into the account owned by the applicant. This payment made by Eco Trading, owned by Mr. Malima, which totaled round about 2 million. He reiterated that it started with 18 million and Enercon received 9.5 million, which is transferred to Eco Trading, and 1,470,000 was transferred into Quality Meat Supply, and from Quality Meat Supply, 960,000 transferred to applicant. And then 1.40 million was transferred from Eco Trading to Parkwood CC, owned by the applicant. He further testified that they scrutinized the accounts and found that more transactions were made from Quality Meat Supply to applicant in the amount of 500,000, 550,000, 350,000, and 50,000. Testified that Eco Trading was 100% owned by Mr. Malima, and he also testified that Irongo Trading by Mr. Leon Nandaho, who is also an accused in the matter. But the beneficial was Mr. Austin Elindi. Quality Meat Supply appeared to be owned by Ms. Heleni Itana or Antindi. I'm not sure as to the surname, but I'll refer to her as Ms. Heleni. And the beneficial being Mr. Malima, and Oshali Fuel, the beneficial being Mr. Malima, and the details of the owner was still under investigation. He testified that all the entities are related, coming from one family, Eco Trading being owned by certain Johanna and Martha, which investigations reflected were the biological mother and sister of Mr. Malima, or family to Mr. Malima. He testified that investigations are still ongoing and financial analysis is still to be made, but investigations revealed applicant received between 2 November and 18 December an amount of 1.2 million by Mr. Connie van Wyk, who's also an accused in the matter, who at that time was an acting chief executive officer for Enercon, making deposits into the account of EcoFuel Trading. He testified that the debt of 73 million was ceded by EcoFuel Investment CC to Enercon. In addition, there was a debt of 35 million that was accumulated by Enercon, and at this point Namcor was exposed to debt of 180 million, despite the account having earlier been settled in July 2022. The witness, Mr. Nambao, testified that the credit policy and the credit limits are clear and the remedies available, and whether there was any anomaly or gray area, there are policies in place that have to be followed. One of the remedies is to refuse further supply to the customer, credit guarantees, and mitigate loss. He further testified that the debt owed by Enercon to Namcor is 35 million. He testified that Irongo Petroleum CC also has an outstanding debt of with Namcor in the amount of 277 million based on the reconciliation of the invoices. He further testified that they started at a credit limit of 3 million. This is Irongo Petroleum, which was increased to 10 million, and they provided a credit guarantee of 10 million, of which 4 million was cancelled without reason, and Irongo Petroleum had incurred a debt of 238 million above the credit limit. The witness testified that the applicant was involved in 3 purchase orders named 113, 117, and 119, approved for Irongo Petroleum, and investigations from Namcor staff members, including emails which were marked Exhibit G1 to G3, revealed that applicant had instructed or approved Irongo Petroleum only to be invoiced once a purchase order is complete, as opposed to invoicing them per load. The witness testified that the purchase agreements or the purchase orders amounting to 26 million, 2.9 million, and 30 million, respectively by Namcor to Irongo Petroleum. The witness, Mr. Nambao, testified that this information was obtained from Namcor staff members. Mr. Nambao testified that he was involved in the asset acquisition and received money that came from Irongo Petroleum, transferred into quality meat supplies and into the applicant's personal account, which he identified as money laundering. The witness further testified that through $1 million in his accounts and was liable for tax in the amounts of 20 million, which accused had not paid to the Namibia Revenue Agency, NAMRA. The applicant only declared an income of 2 million for a period of 2022 and 2023. He further testified that of the 62 million received, there were 12 million which were cash deposits. He further testified that he is aware that the applicant had raised objections at the NAMRA office, however, contended that applicants still owed NAMRA in close to 20 million in taxes and had failed to provide invoices to indicate otherwise. No invoices of quality meat supplies and further documents were received reflecting that the applicant was unemployed, and at the same time he also was provided ample time to collect the invoices to substantiate in the amount that the applicant approved for the 3 purchase orders to the value of 26 million, 38 million, which is approved on 6 April 2023. If you can take a 10-minute break, I think it's very hot for me right now. We will adjourn for 10 minutes and the court will return. Yeah, I'll proceed from where I left off. Mr. Nyambali testified that the amount received between July 2022 and November 2022, 960,000, 500,000, 550,000, 350,000, and 50,000 from Quality Meats Supply and into the applicant's personal bank account. The applicant testified, Mr. Nyambali testified that he came across the approved budget of Namcor for the year 2022 and 2023 in the amount of 25 million, and board approval would have to be sought for the movement of funds. He further testified that the board only became aware of the acquisition in April 2023 after it had received an anonymous report in April 2023. Mr. Nyambali testified that the Namcor's consolidated Apex budget, which is marked Exhibit F2, provided an approved budget or budget approval of 25 million. Anything above that would require the board's approval. Mr. Nyambali testified that they arrested the applicant first from all the other accused persons, as he was a frequent traveler and feared that he would not return or would flee to South Africa. He testified that the arrest was a joint effort between the ACC and Namcor, and the applicant was apprehended at his house in Hockland Park. Mr. Nyambali testified that the arrest was made by the Namibian police, who had the authority to execute the search warrant. He testified that Commissioner Becker executed the search warrant, and accused was handed a copy of the search warrant, legal and constitutional rights in his presence. In order for them to get into the property of the applicant, someone had to jump over the gate. The gate was eventually opened from the inside, and they were able to walk in. He testified that the applicant had locked himself in the room for 1 or 2 hours, and he had been in the... He testified that they entered the room, and the applicant's cell phone was ringing, with calls coming from Mr. Semaneka, as well as from Mr. Mulunga. He testified that the applicant was calling his fellow accomplices, as he put it, and although he did not look or search for call records at the time of the arrest, he stated that not an hour passed before Mr. Malima had crossed to the border of Oshikango. Mr. Nyambali testified that on that particular date, they seized applicant's cell phone, laptop documents, including the vehicle registration documents and farm documents. He further testified that the applicant was asked about any chronic medication and illnesses, and the applicant informed Mr. Becker that he was diabetic. He was requested to carry his medication with him to the police station, which he elected not to do. Mr. Nyambali testified that the day the applicant, he received a call that the applicant was being escorted to a hospital by a certain Mercedes-Benz GLC63 white SUV. He testified that there were 2 other law enforcement in a single police van, and the applicant was at the back of the van, and the police reservist was behind the police in the GLC. He informed court that the senior police officer in the car had narrated that they did not have had adequate transport, and as a result had requested for the reservist to assist with transport, and the police van they had used was borrowed from the Klein Windhoek police station. Mr. Nyambali stated that the senior officer is a reservist in the reservist vehicle, was cautioned, and the misunderstanding was cleared. The officer was excused, and Mr. Nyambali proceeded to escort the applicant to the hospital while the Mercedes vehicle was released at the Correctional Services Facility. Mr. Nyambali testified that the biggest fear they have is the suspect fleeing, especially a foreigner or someone with dual dual citizenship, especially that they had just returned a debit card of the applicant and a vehicle to the applicant's sister. Mr. Inambao, in response to the state prosecutor questioning him why such a hospital incident was not put to the accused or Mr. Mulunga, Mr. Inambao testified that the police reservist had a relation to one of the accused in the matter, but would not disclose which accused, and further refuted that the hospital incident had any connection to Mr. Mulunga, that no evidence showed Mr. Mulunga's involvement. Mr. Inambao testified that no bail conditions can be proffered and objections to bail remains. He further testified that they feared applicants' dual citizenship or nationality as a result. They feared the abscondment, that it was very high. He further testified that the accused had been sending money to South Africa, to bank accounts in South Africa. He further testified that there is indication that accused had sold property in South Africa, and that there's indication that such monies is still believed to be in South Africa. He testified that an applicant is facing serious charges and the risk of evading is high. Mr. Inambao testified that the two passports are in the possession of the ACC, which were seized on the date of arrest. He further testified that the Namibian ID and the South African ID is in possession of the applicant's lawyer, Mr. Isaacs. Mr. Inambao testified that interference into investigations by the applicant is high as part of the money of the applicant remains in South Africa. He further testified that the transactions are complex, involving money laundering, multiple persons, and multiple transactions were concluded. Mr. Inambao testified that Namcor is a public enterprise, and Namcor Trading and Distribution is registered as a private company, and its primary duties is to carry out business for its parent company, which is Namcor Holdings. And Namcor Holdings receives government levies, which benefit Namcor Trading. He further testified that Namcor receives bailouts from government, and the case revealed that there are activities relating to money laundering which have been covered by the media. From the evidence presented to court, Enercon was above the credit limit of 15.5 million, and further he testified that the debt resulted in above 65 million, and the debt recovered was rejected by Namcor in 2023. Mr. Inambao informed court that close to 400 million was lost, and they have demonstrated a strong case and conspiracy dating back as far as 2021 involving Namcor staff members. He declared that it would be in the public interest and the administration of justice that accused be remanded in custody and denied bail. He further testified that the suspects are still to be arrested. There are suspects still to be arrested, and bail proceedings have slowed the investigators in terms of investigations. He further testified that with adequate staff, it may take about 4 to 5 months to finalize investigations. That is in terms of the local investigators. He indicated that he cannot say how those outside the country would have to assist the local investigators, how investigations will transpire in terms of the investigators outside the country. Mr. Inambao further testified that the invoice of Parkwood to Eco Trading made on July 2022 of 1,040,000 presented to him by Advocate Lulungwe is a fabrication, as the transactions into his personal account only started after the purchase, asset purchase agreement. I now move to the law. The onus is on the accused to satisfy the court on a preponderance of probability that he is a suitable candidate to be released on bail. In S versus Duplessis, a 1992 matter, at the time, Judge Olin stated that liberty of the subject, fair trial, and the principle of an accused person is regarded as innocent until proven guilty, and stated that these very important fundamentals, rights, are, however, not absolute, but circumscribed and subject to exceptions. Further, Section 61 of the Criminal Procedure Act states that if an accused who is in custody in respect of any offense referred to in Part 4 of Schedule 2 applies under Section 60 to be released on bail in respect of such offense, the court may, notwithstanding that it is satisfied that it is likely that the accused, if released on bail, will abscond or interfere with any witnesses for the prosecution or with the police, refuse the application for bail, if in the opinion of the court, such inquiry, as it deems fit, as it deems necessary, it is in the interest of the public or the administration of justice that the accused be retained in custody pending his trial. In S versus Atchison, 1991, Judge Mohammed, as he was known then, emphasized that an accused person cannot be kept in detention pending his trial as a form of anticipatory punishment. The presumption of the law is that he is innocent until his guilt has been established in court. The court will therefore ordinarily grant bail to an accused person unless this is likely to prejudice the ends of justice. In Charlotte Botha versus the state, Judge Olin stated that a judicial officer will therefore obviously have to make a value judgment of what are legal convictions of society and what is the impact of such convictions on the particular case where court must adjudicate on a bail application. In Bronco versus State versus Bronco, 2002, Acting Judge Shakalia stated that the fundamental objective of bail in a democratic society is to maximize liberty. The proper approach to a decision in a bail application is that the court will always grant bail where possible and lean in favor of and not against the subject, provided that it is clear that the interest of justice will not be prejudiced thereby. In Nipunya versus the state, a full judgment that was delivered on the 14th of October 2022, it was stated by the three judges, or the full bench, the net is cast wide to the extent that the court has a discretion to refuse bail in public interest or the administration of justice. Even if it is satisfied, balance of probability, it is unlikely that the accused will abscond or interfere with witnesses or investigations of the case. Bail can accordingly be refused if the presiding officer, after consideration of all facts placed before the court, is satisfied that there remains a reasonable possibility that the accused will abscond or will interfere with state witnesses or will interfere with investigation. This would play a vital role where it has been established that a strong prima facie case against the accused or where the accused elects to lead evidence and admit guilt. To this extent, this would count against the accused for release on bail because of the public interest or the administration of justice. Further, in that same case, it was stated that other factors considered in the Section 61 inquiry include whether there is a strong prima facie case that an accused is guilty for one or more serious offenses, the likelihood to commit offenses, the probable heavy sentence as incentive to abscond, and the gravity of the manner in which the offenses are alleged to have been committed, the state of police investigations, previous convictions, the circumstances under which the crime was committed, and whether the public must be protected against a dangerous offender, the propensity to commit further offenses, whether there has been a public outcry over the commission of the crime committed, interest of justice, the interest of the accused and bail facts, fear of committing suicide, medical condition of the accused, multiple serious crimes, serious escalation of crime, and the escalation of accused persons evading the course of justice by absconding. In my analysis of the evidence, there are facts that are common in terms of the evidence, and as provided in the bundle of unopposed documentary evidence handed up, the court is grateful to the parties, specifically for the documentary evidence, for it sets common matters in perspective. It is common cause that the applicant entered into a year-long consultancy with Namcor to provide consultancy services to Namcor, commencing the 1st of June 2020, which agreement was subsequently extended and lasted until the 1st of June 2022. Per the unopposed oral evidence, on the 9th of May 2022, applicant was offered permanent employment as a supply and distribution manager, downstream and supply and logistics department of Namcor. The applicant held this position until the 15th of November 2023. 1 month after assuming the position, he also acted as sole executive for supply and logistics. The job description, which indicated a supply and distribution manager, entailed the development, refining, managing the operational capacity of downstream logistics department, ensuring effective supply of the oil, petroleum products as per market, customer needs. Is also charged with the commercial and marketing functions, the optimal storage and distribution of these products in order to ensure availability of Namcor's products in targeted markets and their positioning at the customer's premises to optimize sales of this product at all times. The bundle of documentary evidence handed up to court also contained the schedule of authority for Namcor, signed by the chairperson of Namcor, Board of Directors, and in terms of the schedule, it stated that this policy is implemented to ensure that management has appropriate legal authority to exercise powers and to carry out certain actions for which they are individually and personally accountable. It also sets out the procurement approval levels, breach policy, and reporting breaches. Further, Namcor financial policies and procedures dated 2007 set out the procedures regards acquisition of fixed assets for acquisition of items not budgeted for. Accordingly, the MD is the approving authority to the approval of the board. The credit policy of Namcor, which is also provided in the set of the bundle, sets the guidelines for the consideration of extended credit terms to Namcor's customers for the purchase of fuel, jet fuel, and lubricants. The object of the policy was to ensure that all monies that are due and payable are collected within the term set out by the conditions of credit. The policy aims to reduce bad debt and to manage the risk associated with granting products on credit. As per the credit policy, the credit applications up to 500,000 are reviewed by the credit committee and recommended for approval. It is worth noting at this stage that it is common cause that the applicant was the acting executive for downstream supply and logistics from July 2022. As per the internal memo dated 8 July 2022. The credit policy states the roles and all credit applications above 500,000 should be reviewed by the credit committee and recommended for approval by the managing director. The policy further stipulates that Namcor Executive Finance, Executive Downstream Supply, and the Managing Director will take all credit decisions relating to customers, including credit limit determinations and all allocation to individuals operating units as recommended by the committee. The Namcor customers were also mapped out into categories, the risk categories being influenced by the customer's creditworthiness, from low risk, categorized as A, medium risk B, high risk C, and no secured credit D. The fuel supply agreement between Namcor and Irongo Petroleum was executed on the 10th of November 2020, at the time the applicant was a consultant for Namcor. The fuel supply agreement between Namcor and Enercon was executed on 16 March, at the time the applicant was a consultant. The asset purchase agreement between Namcor and Enercon came into force on the 15th of July 2022. At this time, the applicant was a permanent employee of Namcor as a manager of supply and distribution and sole acting executive for supply and logistics. The applicant presented evidence explaining personal circumstances summarized above. He denied any criminal activity and that the general increase of credit limits in Namcor presented an anomaly and business decisions were made for Namcor's increased profitability. He contends that his involvement in the transactions was merely an advisory capacity at the instance of the managing director. Further, that he possessed no power or authority to make the decisions. The applicant states that the business dealings with Mr. Malema of Quality Meat Supply were purely farm business transactions without conflict with Namcor. And at the time he was involved with Mr. Malema, EcoFuel had already ceded debt to Namcor without his involvement or engagement. The applicant denied any corruption, fraud, theft by false pretense, money laundering, and any conspiracy with Namcor staff and Enercon. He further informed court that he would plead not guilty to all charges and would afford bail of a maximum of 20,000 if any conditions were placed, he would comply. He denied having any plan to abscond and that his business and family were rooted in Namibia regardless of his dual citizenship. He invested in a farm which he intends to create into a game lodge and has no intention to move to South Africa but clear his name and restore his finances. The state led evidence on the transactions that were made into the applicant's personal bank account, that such money was transferred from Enercon, Eco Trading, and the beneficial being Mr. Semaneka Victor Malema, and an amount of 3,010,000 was paid, and these transactions occurred between July and December 2022 when the asset purchase agreement came into force. It is the state's contention that the 3,010,000 paid into the applicant's standard bank account is as a result of bribery money for the asset purchase agreement that had been signed between Enercon and Namcor. The evidence presented before court is that no transactions of a similar nature had taken place before the conclusion of the asset purchase agreement. It further appears to be the state's case that the flow of money between Namcor, Enercon, Eco Trading, Quality Meat Supply, CC, and the applicant coincides with the asset purchase agreement. Thus to say that the state seeks court to conclude that money that ended up with the applicant was for nothing else but bribes and proof of corruption on the applicant's part. The state would have court believe that the applicant was a conspirer with other executive members of Namcor, his co-accused in the matter. The applicant's defense is that he was an employee of Namcor, tasked with the duties of being a member of the credit committee, applying the credit policy with a holistic approach in the furtherance of the business affairs of Namcor after July 2022. It is further his defense that he was in no capacity to take a decision for the conclusion of any of the agreements in question, and that his involvement before July 2022 was confined to a supporting role within the limitations of his position held at relevant times. And I pause here to revert to the state's specific grounds of objection, which are risk of interference, the risk of abscondment, the seriousness of the charge in the strength of the state's case, outstanding and suspects and investigations, public interest, and the administration of justice. For the purposes of this ruling, the two grounds of objection, which are the risk of interference and outstanding suspects and investigations, will be discussed in tandem. The state has informed court that investigations are pending and that they require an additional 4 to 5 months if they are adequately staffed, and that there are outstanding suspects to be arrested. The fact that investigations and outstanding suspects are pending should not in isolation be a reason to refuse bail to the applicant. One of the factors that the court must consider to determine whether the applicant is likely to interfere or tamper with evidence. Mr. Inambao testified that the applicant had received calls from Mr. Malima and Mr. Mulunga during his arrest, which was negated by the applicant, and proof of call records were requested. Mr. Inambao confirmed that they have not obtained any call records. The state tried to paint a picture that Mr. Malema is at large because the applicant was able to alert him. I say so due to the state's evidence surrounding the arrest of the applicant at his residence. Supporting evidence in the form of call records are critical evidence to show the intention to interfere that the court could have expected the state to produce such evidence. The applicant indicated that he was aware of the investigating officers questioning friends during the investigations in 2023. His laptop was seized with the ACC officials. He's unaware of any other particular witness or investigations that he would, since documentary evidence was already with the ACC officials. Indeed, the accused bears the onus that he will not interfere with investigations, and the state cannot raise objections and sit back without bringing credible evidence before court to support this objection, in the hope that the accused will not dispense of the onus. The objections of the state must be serious, for incarceration encroaches on a constitutional right to liberty and should be done so within the constitutional limits. In this instance, there is no evidence before court to suggest that indeed there is a serious risk of interference with investigations or with witnesses, or that the accused will in any way impede the arrest of any other potential accused person. Further, the court is of the opinion that there is no sufficient evidence before this court that bail conditions cannot address that fear of interference. It is for this reason that the court will not delve any further with regard to those specific grounds of objection. This leaves the court to consider the risk of abscondment, the seriousness of the charges, and the strength of the state's case, public interest, as well as the administration of justice. It is tried, and it is settled in our law, that in essence, the question of the administration of justice and the public interest in bail applications entails a consideration of all other grounds of objections, the traditional factors as they're called, such as the abscondment, for which the seriousness and the strength of the state's case are amongst the factors to be considered. For if the labor of the state's case is so serious that evidence against the accused is so strong that there's a likelihood of conviction at trial as to induce the accused person to skip bail because he fears a lengthy incarceration. I now turn to the personal circumstances of the accused person before court in relation to the applicant. Indeed, the applicant is connected to both South Africa and Namibia. He holds dual citizenship of both countries. He has families in both countries. He has been a frequent traveler between the two countries. He contends that he is rooted in Namibia, established himself in Namibia, and has chosen Namibia as his primary home between the two countries. He has a farm to the value of 9 million. He lives in Namibia. 2 of his children reside in Namibia with their mother when they're not schooling, and his siblings live in Namibia, and his mother resides in Namibia. The defense argued that the state is solely relying on his wealth, but he argues that it has been aware, that he has been aware of investigations since 2023 and has not evaded or left the country. This court is of the opinion that, as it was discussed, an extradition treaty between Namibia and South Africa is a factor that increases the possibility of the state being able to bring the accused person to book should he abscond. The further question remains, however, whether or not the charges and the state's case could be a catalyst for the accused person to abscond. Indeed, it is common cause that corruption is unacceptable in Namibia. Taking into account all policy pronouncements by government, followed by the enactment of the Anti-Corruption Act, various other related legislation, the approach of superior courts in sentencing, and bail in corruption cases. These have been a response to a public outcry and an abhorrence with which the Namibian society views corruption. There is therefore no question that the labels of the charges against the accused person, applicant, are serious and would carry a substantial sentence if convicted at trial. I refer to the case of S versus Ngipunya, and I'll just read the first paragraph. It's in the judgment. Judge Liebenberg stated that it must be remembered that traditional grounds relevant during the bail inquiry include the seriousness of the offense, strength of the state's case, whether the accused will stand trial, whether the accused will interfere with witnesses, and whether the accused is likely to commit similar offenses if released on bail. And these traditional grounds culminate the ultimate question whether the interests would be prejudiced if the accused is to be granted. The court reiterates, however, that the label of the charges alone is not sufficient to sustain the objection of the state on any charge, regardless of how serious the charges are and the sentences may carry. Court must therefore take into account the strength of the evidence against the applicant. The state contended that the applicant received 3 million in gratification wrongful between 2018 and 2023. The applicant corruptly received gratification and increased credit limits of Enercon beyond authorized limits to Namcor's actual loss of 30 million, over 30 million, and corruptly facilitated the acquisition of assets above 53 million in favor of Enercon, and that he falsely represented to Namcor that as a supply and logistics manager, he had authority to authorize fuel supply above the credit limit. The applicant denies all the charges as per the annexures, and under cross-examination, the applicant contended that he does not deal with customers. The only time he does is when they review credit limits or they would deliver fuel through his team. The nature of these types of commercial crimes is that the actus reus would not be obvious. One would expect that the offender would conceal the corrupt reasons using what appears to be legitimate business. Court is therefore specifically of the opinion that an explanation to these transactions by the applicant has to, on a balance of probability, hold water, to demonstrate that on a balance of probability, he has a plausible defense and is unlikely to be convicted at trial. In a bail application, the purpose of so demonstrating is to emphasize to court that regardless of the charges the accused faces, he has no incentive to abscond, and on a balance of probability, likely to stand trial. It is not in dispute that the allowable credit limit of Enercon was 15.5 million, which rose to 35 million. The applicant disputes that he was part of the credit committee and that the Enercon debt had risen. He was a member only from the 1st of June 2022 when he became an acting executive. The applicant does not deny that customers went beyond their credit limit. In cross-examination, he admitted that they do not just block accounts because of the relationship. There are various factors and considerations, and one such was that Enercon was applying the Namibian Defence Force and discretion was taken when needed, that it was not just black and white when it came to commercial agreements and contracts. In essence, the applicant denies any criminality in exceeding credit limits, but rather it was an ordinary commercial transaction in the ordinary course of carrying out Namcor's business activities. The issue of the credit limit and policy system has been described by the applicant as an anomaly, that the credit policy is not cast in stone. But nothing was done because business could not stand still. The anomaly was not fixed, and the provision of credit continued. It is also not disputed that this particular transaction is not the only transaction where Namcor had granted credit to a client beyond the allowable credit limit. Court must state to this end that there is no evidence before this court that suggests that the process of exceeding the credit limit in other cases is any different from what followed in this particular transaction. The state lamented, however, that this very actions were corruption that the accused persons partook in. It is the view of this court that such allegations alone cannot carry the state's objection in the face of the applicant denying having been in a position to sanction the granting of credit and the asset acquisition that leads to these charges. The applicant in cross-examination confirmed that the internal memorandum dated 8 July pushed for a payment of 25 million and that the credit committee convinced the MD for payment of 35 million or to be paid back. The state contended that Irongo had received credit limit of 10 million from the initial 3 million, and the state contends that the Enercon, at the instance of the applicant, received more credit than allowable. It is the evidence before this court that following the credit increase and the asset acquisition, money was paid into Enercon, Eco Trading, and the applicant's personal account. Enercon is paid, Enercon pays Eco Trading pays Quality Meat Supply of Mr. Malima, Quality Meat Supply in turn pays applicant. And in the process, Enercon's acting CEO also pays applicant. It is these above chain of transactions that the state alleged was gratification, bribery, kickbacks towards the applicant. On the face of it, court is now faced with a coincidence and the chain of events. The applicant seemingly having some sort of influence from within Namcor for the asset acquisition amounting to 53 million, at least by virtue of being an employee. It is worth noting at this point that no further transaction for meat or otherwise happens between these individuals before July 2022 and December 2022. Neither is there evidence to show that any further transactions of meat beyond these transactions. This would have demonstrated that the money passing between the dealings has nothing to do with the asset acquisition. The applicant contends that these transactions were purely for meat and logistics. There is, however, no proof of the actual transfer of the meat carcasses between himself and Quality Meat Supply, CC, owned by Mr. Simaneka, before court. One such proof would have been the termination of the cattle slaughtered and sold. I now paused to address the question of whether or not it is reasonable for the applicant to be expected to furnish any proof of these transactions, of the so-called cattle transactions at this stage. The applicant is saying that he has the documentary evidence somewhere on his computer, laptop, seized by the ACC officials or at his farm. The investigating officer corroborates applicants who states, in fact, Your Worship, and I quote, part of the investigations, that is why we even seized the computer during investigations. So the investigations are still ongoing. Maybe we will find, maybe we will not find. I cannot say, but for now, we do not have that on record. That is what Mr. Inambao states. Critically, the admission that we may or may not find it points to an admission that the state itself cannot negate with certainty the applicant's defense, that is to say that the state admits that the accused person may have a plausible defense at trial. At this stage, it is not tested, and court has no choice but to believe the applicant that the proof may be there as to the purpose of transactions and would have been before court had he not been in custody or his computer seized. The state made the allegation that the laptop seized may have been recently purchased in May 2025, but this was also negated that any record stemming as far as 2022 may be located on such laptop. Further, no forensic investigations have taken place to verify any invoices or receipts pertaining to the cattle or meat sales. The applicant testified that there are other small transactions demonstrating that the applicant is involved in other ad hoc transactions of meat and other goods. This was not disputed. the court is of the opinion that at this stage, the accused has a plausible explanation for the money paid into his account that weakens the strength of the state's case and renders the court to be of the opinion that there is seldom evidence of the charges against the applicant being a catalyst to abscond for fear of a lengthy incarceration. The applicant denies the charges of assisting another to benefit from proceeds of crime in the amount of over 327 million. The applicant's bank accounts were presented to court for the period of 2022 and 2023. No accounts from 2018 were presented or put in question by the state or the applicant in respect of that charge. Again, the state only has a mere label. It is the conclusion of this court that whilst the evidence before court warrants sufficient cause for suspicion and investigation, this court is not satisfied that the applicant is unlikely to successfully mount a defense against the compounded, and I emphasize, against the compounded criminal charges against him. And therefore, the court is of the opinion that the charges are unlikely to be a catalyst for his abscondment. Further, the state spheres may be allayed by the imposition of stringent bail conditions. In the premises, the court concludes that the continued detention of the applicant would not be in the interest of justice. As a result, the application for bail by the applicant succeeds. Before I make my order, I just want maybe to address me on the reporting conditions before I emphasize what the conditions will be, the bail amount and the conditions.
Yes, Your Worship. As indicated by the accused, he will be able to report in Ventu. May I just take a short instruction?
You may.
Thank you, Worship. Your Worship, my instruction is if it's the bail condition is every day, it should be Okahanja because the farm is closer to Okahanja. If it's twice a week, he will be able to make it to Ventu because the farm is not that far. In terms of the bail amount,
the courts will provide the bail amount.
Yeah, I'm just saying that it's in the discretion of the court.
The following order is therefore made: that bail is granted in the amount of $200,000, subject to the following conditions. Firstly, the applicant reports daily at the Okahanja Police Station, that is twice daily, that is Monday, Tuesday, Wednesday, Thursday, Friday, between the hours of 8 and 9, and between the hours of 1800 and 1900. Further, the applicant is to surrender all passport or traveling documents not already handed over to the ACC or the Namibian police to the investigating officer, Mr. Inambao, and further that not to apply for any new travel documents until the finalization of this criminal matter. The applicant's passport and identification copy to be distributed at all Namibian borders, that is the Hosea Kutako as well, and Eros Airport. The applicant's residence is to be at a fixed address, and I find that this is in the district of Okahanja, to be verified by the investigating officer upon his release, and any change of address to be communicated and verified in court. Applicant shall not leave the district of Windhoek without written permission of the investigating officer, Mr. Inambao, and further that the applicant shall not in any way interfere with state witnesses or potential state witnesses or tamper with state evidence. That is the order of the court.
Your Worship, the date